Good afternoon or good morning, as the case may be, ladies and gentlemen. This is Mr. David. This is the part 4 of the documentary David versus At&T. At&T stands for American Telephone and Telegraph Company. You heard in the previous documentaries, part 1 through 3, what happened at the United States Court of Appeal in the Second Circuit, the United States Court of Appeal for the 11th Circuit, what happened at the district courts. Now, the kangaroo court proceedings moved from these courts to the District Disciplinary Committee of the New York. As you have seen previously, I filed a complaint against 2 criminals, namely Ralph Curtis Dawson, who is the chairman of the Democratic Party's Rules Committee and also a member of the Disciplinary Committee, for filing papers for getting a summary judgment. His motion papers, you will see, motion for summary judgment in the www.davidkangaroocourts.com. That's where you can get all the documents stated in this documentary. Anybody wants, you can retrieve them from the web. You don't have to go through the PACER system. We have put it for your convenience and for the convenience of law students who are researching. So research scholars, lawyers, law professors, those institutions which teach law in America, namely Columbia School of Law, Harvard, St. John's. These are some of the Yale. These are some of the universities which teach law to the students. I want them all to listen to me. What is happening in the kangaroo courts of the United States? I am so mad I can't put up with this. 33 years of struggle to get justice, and all doors to get justice are closed to me, all the doors. And you have seen step by step what happened at each kangaroo court. Folks, when a person or a corporation commit an offense, if the individual is a poor person, he is convicted. Okay, he doesn't have the money to pay the lawyers. He may be innocent. You have read in the papers, so many people were discharged from the jail because it was found later on that person was innocent. But if it is a corporation who is committing the crime and have the political muscle and the economic power, they can simply walk away. In this case, this corporation, this mafia corporation, which is known as At&T, and one of its former subsidiaries, Michigan Bell, which is now known as At&T, they kept changing names, and then, one name goes to the other and then becomes another company. So these 2 companies have committed crimes. They violated the Title 7 of the Civil Rights Act 1964 as amended. They violated ADEA, which stands for Age Discrimination in Employment Act. They violated ERISA, Employees Retirement Income Security Act, and breaches of a contract against me, because what they did was giving me Monday morning $5,000 merit increase and firing me 4 days later for refusing to accept certain sum of money offered to voluntarily resign. You heard the proceedings, folks. During the last 33 years, I got no discovery at all. I'm going to show you the holding of the district court, the holding of the district court in Orlando and Tampa, the holding of the district court in New York. No discovery, Mr. David. You can't get discovery. This is one of the characteristics of a kangaroo court. You will see, and I'm going to put it up on the web, the colloquy between me and the federal judge Joanna Seibert of New York. She is asking the counsel for the defendant whether plaintiff needs any discovery rather than ordering them to submit to discovery. You understand the gimmicks, folks? 33 years. Law professors, if you teach law to your students, tell them discovery is most important for any litigant in any court. But this kangaroo court says, Mr. David, you get no discovery. You understand? Folks, I filed the complaint with the DDC, District Disciplinary Committee, against these two criminals, Dawson and Tilker, for filing false affidavit. They didn't think at the time I will research about Tilker, who was only 2 years old. In his sworn affidavit, which I put it on the web and you can see it again, Tilker affidavit, he says, opening paragraph of his affidavit, which is sworn and notarized before a notary public, he has personal knowledge. And he goes on to say, on August 25, 1981, Mr. David signed a release. He says he has personal knowledge. How old he was then? 2 years and 3 months old. That's the false affidavit. And anybody with common sense can understand what I am talking about. But the first person they contacted to save their butt is the United States Attorney, a gentleman by the name Preet Bharara. You see the letter signed by David J. Kennedy, Chief Civil Rights Unit. You're going to see the document. Preet Bharara is an Indian born to a Sikh family, S-I-K-H, Sikh family. He is the U.S. Attorney. He is the one who successfully prosecuted an Indian diplomat by the name Devayani. Devayani, it is alleged, she filed some papers to bring a servant to be her homemaid, to take care of her children. That's a crime. She was charged and Preet Bharara indicted her before a grand jury. Now I submitted papers to Preet Bharara's office, the U.S. Attorney's office, not to him personally. And Preet Bharara says, I am reading from the letter, the Civil Rights Unit of the United States Attorney's Office for the Southern District of New York has received your complaint against opposing counsel in your discrimination case. Case 06 CV 3199JS, paragraph 2. We have carefully reviewed the information that you submitted. Based upon the information you have provided, we have concluded that the facts you described do not appear to implicate a violation of the federal civil rights laws over which this office has jurisdiction. This conclusion does not represent an opinion as to the merit of any individual claims that you may have. Please be advised that your letter or complaint to the office has no effect on any statute of limitation that may apply to your claim. By sending a letter or filing a letter or complaint with this office, you have not commenced a lawsuit or a legal or administrative proceeding, and this office has not initiated a lawsuit or proceeding on your behalf. This is signed by United States Attorney and signed by Chief Civil Rights David J. Kennedy. This is the letter from the U.S. Department of Justice, who say Mr. Dawson, who is the chairman of the political party and the disciplinary committee member, has not done anything wrong, nor Mr. Tilker, who filed a false affidavit. See the contrast. Devayani prosecuted for filing a false papers to bring a servant to the United States, allegedly. At the same time, these suckers who filed papers, sworn papers. This guy says, they have not done anything wrong. You know why, folks? Preet Bharara went to Columbia School of Law. And so Mr. Dawson, you understand the connection? One is a chairman of the Democratic Party's Rules Committee. So he is above the law. The ordinary people, none of them are above the law. But when a criminal who is a top official in the government, the Obama administration, and Obama appoints the Attorney General for each state, he hasn't done anything wrong. Folks, use your common sense. You are the jurors. You have to make findings of facts. Look at these papers on the web. Folks, I moved to the DDC, Departmental Disciplinary Committee, District Disciplinary Committee for New York, First Department, wrote in an affidavit that Mr. Dawson, being a member of the committee and the Obama buddy, they don't want to investigate him, he is untouchable. You understand? So they make a motion to the Appellate Division of the Supreme Court of the State of New York, and a 5-judge panel headed by Justice Richard T. Andreas, David Friedman, John S. Sweeney Jr., Sally Munset Daniels, and Nelson S. Roman. These are the judges. Issued an order directing another department of the disciplinary committee to conduct an investigation. It reads, I'm reading from the order. Now upon the reading and filing the papers with respect to the motion and due deliberation having been had thereon, it is unanimously ordered that the motion is granted and the complaint against docket number 87212 is transferred to the Appellate Division, 2nd Judicial Department for investigation and disposition. That's the 5-judge panel order against Dawson. Folks, as I told you before, this is a clique, political clique. Mr. Dawson is a big fish in the net. So they want to save his butt, Mr. Dawson. Okay? So the game is now transferred from 1st Judicial Department to the 2nd Judicial Department. Do they conduct an investigation as ordered by this 5-judge panel? No, folks. These guys, Dawson and Tilker, are above the law. So what they do? 2nd Department, instead of conducting the investigation as ordered by this 5-judge panel, submit that papers to a staff attorney, like a receptionist. Give it to the staff attorney. Staff attorney says, oh, we haven't found anything wrong. No, not we. He says, I haven't found anything wrong. So he doesn't want to submit to the court. The staff attorney is not the court. He is only a receptionist in a disciplinary committee office. Okay? So Mr. Dawson off the hook. You understand the name of the game? What about Tilker, the sucker, who submitted the false affidavit? Oh, they give it to another guy. His name is Myron Martinez. Myron Martinez says, oh, he hasn't done anything wrong either. Folks, this is the type of investigation conducted by the DDC, the District Disciplinary Committee of the New York Bar, about 2 felons who committed crime. They don't want to prosecute him because one is Obama buddy, the other one is his assistant, his former counsel. Folks, when This matters go to the another court. Before you go to the next court, which is called the Court of Appeal, that's the final court in the state of New York. No other court above that. Court of Appeals. Now they did one more trick. They went to another judge, another panel of judges. Okay, they don't conduct investigation. So I filed a motion compelling them to conduct investigation. Now Mr. Gildo comes, Mr. Gildo, Robert Gildo. You see his letter. He is not the clerk of the court. When you send communication to the court, you don't address to the judges, you write to the clerk of the court. So Mr. Gildo, who is not the clerk of the court, picks up the paper, he takes his own decision instead of submitting to the court. And my papers that was sent to the second judicial department, they got lost in the mail, registered mail, sent from India with a tracking number. It lands in New York, then it disappears. You understand what is going on here? It's not lost in India, not lost in transit. It landed according to the tracking number. Then the motion paper disappeared. Mr. Gildo write to me a letter. Right? He says in his letter, Mr. David, we don't conduct investigation against lawyers which was decided by another court. You understand? Then he says, Mr. David, you got to file a docket number. You got to buy a docket. There are 2 dockets against Dawson and 1 docket against Tilker. Now this guy, who is not the clerk of the court, writes on behalf of the court or the clerk, I have to buy an index. So they return my papers. Mr. David, we don't traditionally conduct investigations. We hush up. Especially the fish in the net is a political powerful person. Mr. Dawson is a partner in an international law firm with 3,500 lawyers working 24 hours. So this is how the firm Fulbright and Jaworski, then now Rose Norton Fulbright and Jaworski, functions, filing false affidavit and protecting the lawyer who did it to get scot-free. Folks, you got to understand what is the issue before the Orlando and Tampa and New York federal courts. Mr. David's timely filed age discrimination, Title VII, ERISA, and breach of contract claims. Were they ever addressed by any of the courts? No, folks. None of these kangaroo courts wanted to examine my claim that was filed by counsel Syriac D. Capel in 1982. You understand? As of today, February 7, 2014, that case was never decided. It was shifted from one kangaroo court to the other, and they tried to divert the attention of the court from one issue to the other, never focusing on their main attention to the issues that I raised. Now, the second panel of the first judicial department, which is headed by David Friedman, Helen E. Friedman, Rosalind Richer, Paul G. Feynman, and Judith J. Gish. These 5 judges, the first panel says, conduct an investigation. There's the papers. The second panel says, no, don't want to conduct an investigation. Okay? Because they say Mr. Tilker is not guilty, Mr. Dawson not guilty because the staff attorney said so, so we don't want to conduct an investigation. Folks, the problem is when there is a difference of opinion between justices or judges in the appellate division of the Supreme Court, the Court of Appeal has jurisdiction because there is a inter-circuit dispute. You understand? One 5-judge panel says conduct an investigation. Another 5-judge panel says no, we don't want it because this will expose the Obama administration and its officials, top officials, the Rules Committee chairman. So these political panels are differing among each other. One says conduct investigation, 5 judge panel says no such investigation required. Under the rules, folks, when there is a conflict among the judges, the Court of Appeal has automatic jurisdiction. Folks, I filed a motion before the Court of Appeals, Albany, New York, which is located at 20 Eagle Street, Albany. I submitted a motion pursuant to the rules asking the court to invoke its jurisdiction because there is a conflict among the panels. As soon as I filed the motion was opposed by the District Disciplinary Committee. Okay? We are asking the court to investigate. Another court says investigate. Another panel says don't investigate. There is a conflict between two sets of judges in the appellate division of the New York Supreme Court. Now, what Mr. Jeremy S. Garber, he is the Special Trial Counsel for the DDC, did was he opposed, saying that the court has no jurisdiction. Folks, anybody can file any garbage, saying whatever story they concocted. But Mr. Jeremy Garber applied yet another trick here. All the people involved, these are all tricksters or fraudsters. They commit different crimes. So this is the letter from the Special Counsel Jeremy S. Garber, which you will see. And in the letter, he writes the letter to the Honorable Andrew Klein, Clerk of the Court of Appeals, Albany, New York, in the matter of attorney and counselor at law, Talakotura David, movement appellant, Departmental Disciplinary Committee respondent appealing. What he does is, he submits some papers. This is called the affirmation in opposition to the motion. That is his attorney's affirmation. What he does is, he doesn't send me this copy, the affirmation. The cover letter he sent to the clerk of the court says, express mail to the clerk of the court, New York to Albany, by express mail. To Mr. David, who sits in India, he says, CC Mr. David without enclosure. It means they only want to send Mr. David this cover letter, not what is in the affirmation. Because once Mr. David gets this, he is definitely going to respond, telling the court what he mentioned in the affirmation is false. You understand, folks? Every lawyer practicing law in New York knows and should know, when you serve a party with papers, or the court with certain papers, you should serve the other party or parties same identical copies. Mr. Garber, who is a trial counsel, says, Mr. David, you don't need our garbage. We don't want you to respond. You understand? Without enclosures. I waited. The return date of the motion was December 16, 2013. No papers served either on that day or several days thereafter. I called the clerk of the Court of Appeals. They said, we already have the papers. Then I called DDC, Mr. Garber. I gave you the index number or the case number. Mr. Garber says, Mr. David, we served the papers from the court, but we sent it to you by regular mail. When it is sent? December 13. That's the season when the US mail is jammed. Millions and billions of pieces of mail. So he put in the regular mail, but at the same time, he elected to send it to the clerk of the Court of Appeal in New York, in Albany, New York, by express mail. You understand the intent? Mr. Garber agreed upon my demand. He sent me an unsigned copy of his brief, this unsigned, okay, by email. Now when I read this, he says, there are 2-3 things striking. He says, David's motion for leave to appeal should be denied because there is no basis to support an appeal as of right under CPLR 5601. No justice descended from the October 9 order 5601 of the CPLR. The October 9, 23 order does not involve the construction of New York State Constitution nor of the United States. The October 9, 2000 order did not grant or affirm a new trial or hearing. Okay? So what he is telling the court is nothing but a pack of lies. Because he doesn't tell 5-judge panel affirmed, wanted to conduct an investigation. The other 5 judges don't want it. He wants to suppress this information. You understand the gimmick here? They don't want the court to investigate or make a decision. That's the underlying objective. As you all know, the Christine Anderson, who used to work for the DDC, she blew the whistle a long time ago. She said the whitewashing of crimes by the very DDC. If it's a major law firm, they can do whatever they want. The DDC will look the other way around, as if they never heard, never seen. You understand? This is a pattern and practice going on in the United States courts and the federal courts and the state courts and the enforcement agencies of this bar association. Now, when I got these papers, I immediately filed a motion for leave to appeal because you do not have right to file a responsive pleading. I wanted to bring it to the attention of the justices, the 7 justices of the Supreme Court of the State of New York. The fraud here. So what happens? The court already made a decision based on Mr. Garber's affidavit or affirmation. And my papers that was sent, they sent it back to India. They don't want to read it. The Court of Appeals denied, State of New York, the Court of Appeal denied motion for leave to appeal. It means that's the end of Tilker walking scot-free and Dawson walking scot-free. 2 suckers, 2 criminals who wear the black suit and go to the court and say, I affirm. These are the criminals. They walk away in the United States courts. Folks, do you trust the courts in America? I'm a US citizen, I don't trust them anymore. Do you? Tell me. Those who trust the United States government or its judiciary, call me and tell whom you trust. You know my number to write to me. The Kangaroo Court, David versus AT&T, you will see the proceedings. This is the part 4. So the state of New York says, motion for leave to appeal denied. Folks, this is America, United States of America. They can prosecute Devayani, an Indian diplomat, for filing or allegedly filing an application to bring a servant to the United States. But at the same time, 2 crooked lawyers who filed false affidavit, sworn affidavit, they walk scot-free. And what is at stake, folks, is my right as a United States citizen. Did I get justice? What about my pension? I wrote to the Department of Labor. Department of Labor, the new Secretary's office says, Mr. David, we tried to get the papers from this mafia corporation. We can't get it. What do you want us to do? They are asking me, an arm of the United States government, the Department of Labor, says they can't get my papers, my employment records. They disappeared in the thin air. My employment records for 9 years. What about my pension? This slut, Seibert, Joanna Seibert, I spat on her face. She says, Mr. David, you signed the release. Mr. Tilker said so. Mr. Tilker said so. Mr. Tilker said so 12 times at different places. The basis of her decision to grant a summary judgment in favor of the defendant is Tilker's sworn attorney affidavit, which is false. Folks, you don't write, you don't deny a United States citizen his right to liberty and property without the due process. You understand? Now, Judge Seibert's decision, as you all know, affirmed without opinion. When you raise issues on appeal, it is the role of the appellate court to de novo consider the issues. But this puppet court, consisting of John Walker, Rena Raggi, and Rakoff, district judge sitting by designation, they don't address any of the issues. Folks, what was Judge John Walker doing in AT&T premises on a dirt road where he killed a policeman guarding that building? What was he doing there? He was under drugs, alcohol, or something else? Why he was not arrested? If I kill a cop on the road, I am immediately arrested. I am tested for alcohol, breathalyzer test administered. Take you to the hospital for blood alcohol, drugs. So this judge who affirmed the decision of the district judge was doing something in AT&T's premises. Folks, those who have sense, think about it. What did these 3 puppet judges in the Court of Appeal did? When you raise an issue, you should have an answer. I'm not a practicing lawyer. I don't know how many of you argue your own case. One of the things people have to remember in America is if you seek redress to any of your grievances, and either under the ADA, Title VII, doesn't matter, one of the statutes passed by the Congress, the lawyers don't even want to know you unless you are prepared to pay maybe $100,000 up front. They say, no, Mr. David, we don't have the time. I went hundreds and hundreds of lawyers, paid them $1,500, $500, $12,000. $300. Consultation fee. The first thing they ask is, who is the defendant? At&T. No, Mr. David. Oh, we are occupied. We don't have the time to handle your case. Why? They all know the tactics of this mafia corporation. You understand, folks? So you remember in your mind, when you deal with this mafia corporation, any time they have highly priced lawyers protecting them, they will destroy you. Filing motion after motion after motion. They filed in my Orlando action. This is the motion papers. You understand? These are all motion papers. This is the jury trial demanded. These are lawyers involved. This is me and my lawyers. You understand? Every day they keep filing motion and they get paid for each motion $3,000 to $5,000 as their fee. So the tactics is to bury you with the motion practice, and many ordinary men and women who do not know the law or who cannot afford to pay the high-priced lawyers, they have no justice. Folks, I'm not a criminal. I have never was. I will never be. I come, as you know, from the country of Mahatma Gandhi, who taught us ahimsa or non-violence. But American people are not that stupid. They understand what goes on here in the kangaroo courts of the United States. Folks, the US Supreme Court rules say when a judge, a federal judge, makes findings of facts or makes decisions contrary to the standard previously set by the court, the Supreme Court of the United States has jurisdiction. Rule 10 of the Supreme Court rules says, review on a writ of certiorari is not a matter of right, but a judicial discretion. It means people think anybody can go to the US Supreme Court and you can have a day there. Forget it, boys, girls, lawyers. You all know it. Supreme Court doesn't hear appeals. It is a discretion. You understand? Now, the discretion. Now, another thing I want you to understand to educate the world. The Supreme Court politics is worse than in the court below. It is not the justices of the Supreme Court. They are senior citizens. Out of the 9, 8 of them are senior citizens. Only Justice Roberts is not a citizen, not a senior citizen. They don't get the files. If you file a petition for writ of certiorari, the justices don't read it, they don't get it. Do you think that the 9 men and women occupying the federal Supreme Court of the United States of America have time to read the 5,000 papers filed? They don't read it. They are assigned to the law clerks. So the name of the game is using the law clerk assigned to the justices to either persuade them or dissuade them so that it will not be brought to their attention. Rule 10, I'm talking to Rule 10. It goes on to say, the Supreme Court has jurisdiction if a state court of last resort has decided an important federal question in a way that conflicts with the decision of another state court of last resort or of a United States Court of Appeals. C. A state court or a United States Court of Appeals has decided an important question of federal law that has not been but should be settled by this court, or has decided an important federal question in a way that conflict with the relevant decisions of this court. So theoretically, the Supreme Court has jurisdiction if it can be shown that the decision of the lower court in this case, the Centralized Federal District Court in Eastern District, her decision is totally contrary to the law. First, she says, during a pre-trial conference held on the phone, Mr. Dawson never appeared in the court. He is the invisible Charlie. During the last 6 years, this case remained in the district court. He never appeared. He does his work through the angels. So the pre-motion conference is on the phone. That's how the judge conducts pre-trial conference with the counsel for the other party. She says, Mr. David, you don't get any discovery. You don't want discovery. I will consider after your death. You understand? Before you grant a motion for summary judgment, the judge has to decide, and she ought to do, that the parties were given the discovery. That's the weapon with which you attack the other. She said, no, Mr. David, no, we don't want it. See the colloquy between me and this slut in the pre-motion conference held on the phone. She's asking, Mr. Dawson, does the plaintiff need discovery? He says, no, ma'am. He doesn't address the issues. He says, Risa, the plan administrator has decided Mr. David is not entitled to pension. What about my ADA claim, Title VII, Risa claims, breach of contract claims? No, Mr. David, we can't give you any of the things. If I do, my client will lose. And I am here a political partner going with the corporation. I am running a court of the corporation, not a United States government. Folks, it's a scheme. Senator Schumer, Chuck Schumer, who is a Democrat, my senator, I wrote him. No response. Folks, I voted for him. No response. I wrote to Gilly Brandt, the new senator who replaced Hillary Clinton. She says, Mr. David, we are a separate branch of the government. We can't interfere with the judiciary. Theoretically, under the system of checks and balances, each organ of the government has to investigate the other. How did the FBI investigate one of the federal judges in Miami? They arrested him in his chambers. So at that time, there is no question of the separation of the theory of powers. A FBI agent can come, arrest a federal judge in his chambers in Miami. You understand? So this senator says, no, Mr. David, we can't do it. Write to the Department of Justice. They say, Mr. David, we can't do anything. Do you think, folks, anybody getting justice in America? Do you think seriously? Folks, all the documents I'm speaking about can be found www.davidkangaroocourts.com. You have my number, phone number. You can send me an email, trdavid2009@gmail.com. My phone number is New York, 631, area code 841-6222. And another number, 516. Let me read, I can't remember every number by heart. My other New York number, 516-216-4185. Any of you viewers, if you have any question, ask me. It's the saddest day for America. I went to America 40 years ago, more than 40 years ago, thinking it's a land of opportunity, land where you can bring up your children, have a wonderful life. Today, I have very sad memories. So you too. Those who want to go to America, think about, consult me before you get your immigrant visa if you are lucky to get one. This is the type of justice U.S. citizens, not aliens, not visitors, U.S. citizens getting from the American courts. lawyers, law students, professors, judges, if you happen to read these kangaroo court proceedings and read and go through the documents, you will see the proceedings in Orlando, Tampa, Court of Appeal for the 11th Circuit, the District Court in New York, the Appellate Court, the DDC. They were a mockery of justice, a total mockery of justice. And you know why many disgruntled and frustrated Americans take the law into their own hands? Like the guy who killed Judge Robert Barnes by sending him a bomb in the mail. People can't put up. Can't put up. Our Department of Justice must clean itself first. We have to clean up the DDC. If we don't clean up, what has happened will happen again and again in America. There will be bloody bloodshed. We preach the world. We are a civilized country. We do everything right. We believe in the rule of law. President Obama, Michelle, I send you letters. When you retire, read the kangaroo court proceedings. We will save it for you. To understand what goes on, pick up the phone. Tell AT&T chairman, this is not right. I want the whole world to call AT&T. Tell them, you may get away from this because Mr. David is a single person fighting against the mighty Goliath. But more Davids will arise. All right? President Obama, if you hear or your assistants bring it to your attention, tell them to investigate what Mr. Dawson did. He's not going to get any fame. He's a fraudster. His co-counsel is another crook. Although he fled to Hawaii and practiced law there, you can understand this sucker, he got an award for writing ethics. And the New York bar doesn't want to give me a copy under the Freedom of Information Act. He got an award. A criminal who filed false affidavit, he got an award. You go into the website, he got an award for ethics. You understand? Folks, I want to wish you all the best, all my American friends, my children, my grandchildren who live there. I'm not interested in coming back to America. If this is the kind of justice I'm going to get as a United States citizen, I can understand what kind of justice you will get it. An Indian attorney, quite recently, he was drunk driving. He hit an electric pole. They were watching him on the camera. They went and arrested him. I don't know, according to the press report, he took a check and gave it to the cop for $2,000. He was arrested. I don't know whether he went for a trial. He was spending his weekends in jail because he's an Indian. You understand? Devayani is an Indian diplomat. I'm an Indian, although I have passports from Britain and America. But they treat you differently. Doesn't matter how many laws the Congress pass. There should be enforcement machinery. There should be means by which citizens of the United States can get justice. I may not come back, but there are many in America who will be forced to take law into their own hands unless and until the U.S. Department of Justice investigate this case thoroughly. They can't investigate on their own. They have to get input from me. How and wow this corporation, in concert with the various federal judges, not one, so many in the link. I wanted to repeat this. There are so many honorable judges in the United States. But these corporations, mafia corporations, they know how to channel the cases to judges of their choice. That's the name of the game. You understand? How to channel cases to judges of their political connection. How to pay judges under the table on a Friday or the beginning of the month in a sack. People, you got to ask the appeal court judge, Court of Appeal, United States Court of Appeal Judge John Walker, what was he doing AT&T premises? Google it. Says Judge John Walker was going through a dirt road to Connecticut and killed a policeman who is guarding AT&T's premises. What was he doing there? People, if you have common sense, ask yourself these questions. What is happening in America? Why Judge John Reed resigned from the bench after he confessed he was approached by his former law clerk, Annie Conway, because they want to make a deal under the table with him to let them off the hook. So this woman, who filed false papers in court, especially jurisdictional statement, telling the United States Court of Appeal for the 11th Circuit that it court has jurisdiction from an interlocutory order, she should be ashamed. She's a federal district judge, chief federal judge. And Peter Sinova, who filed the papers and invoked the court's jurisdiction and dragged my case to a panel of kangaroo court judges. You know, Judge Vance was murdered. Judge Clarence Allgood, the second judge in the Court of Appeal, who was present when my oral arguments commenced, he committed suicide, took a gun and shot and killed him. Maybe in shame, or he can't do any more favors. People, you have to understand what I am talking, how mad, how angry I am. You can't spend 33 long years without moving to the federal court for a day. No hearing, no trial, no jury trial. Folks, these are all guaranteed constitutional rights. No discovery. No discovery. What this mafia corporation is afraid of. Why I was prevented from getting discovery. Judge Reed's order, initial order said, the trial will be limited to the validity of the release. Did the court conduct an evidentiary hearing with regard to the validity of the release? No, folks. They accomplished through the sucker Tilker's false affidavit, which this crazy woman accepted for gospel truth, saying that, oh, Tilker being an attorney and he's a buddy of the Obama and the Mr. Dawson, he can file such a false papers. So here, the party is winning based on false papers. If I did it, I'll be prosecuted for crime. If it is Mr. Tilker or Mr. Dawson, they look the other way around. But did he see? Oh, Mr. David, our one-man committee, unnamed committee, didn't say it. Folks, please, I beg of you to give your verdict. Email me and call the sucker company, call the chairman of AT&T, tell them the world is understanding. Folks, that is all I have to say. Any questions you have, email me. Any documents you needed to review, if you are a lawyer, law student, law professor, write to me. I will provide it in my website. I want to thank you all, gentlemen. Thank you.